Hello, everyone. Welcome to our panel discussion on cross-border trademark infringement and protection, a global perspective. Today, we delve into a matter of utmost significance in the global business landscape, cross-border trademark infringement and protection. In an increasingly interconnected world where businesses operate across national borders, safeguarding intellectual property rights has become a crucial challenge faced by organizations around the globe. Trademarks serve as valuable assets for businesses, representing their brand identity, reputation, and goodwill. However, as companies expand their operations beyond their home countries, they often encounter the complex terrain of cross border trademark infringement. This pervasive issue poses a multitude of legal, economic, and ethical implications that demand a comprehensive and global approach. Today's panel discussion aims to shed light on the multifaceted nature of cross border trademark infringement and explore strategies for effective protection in this dynamic global environment. For this, we have experts with us. We have Sanjay Raphael, a trademark attorney with over 15 years of experience, and he's also well versed in the nuances of trademark protection and devising robust national and international strategies to maximize brand protection. In addition, he has substantial experience in dealing with contentious matters at the UK IPO. As such, Sanjay's experience and expertise means effective solutions which will put in place in order to achieve the best possible results. The next panelist, we have Humna Nadeem. She is a managing associate at TLD. Her background includes advising clients in all aspects of intellectual property rights, from fashion and design backgrounds, national food and leisure brands, entrepreneurs, established tech companies, and startups, as well as celebrity clients. She has worked on complex high court matters, as well as matters issued in the Intellectual Property Enterprise Court, trademark-related issues in the UK IPO, and matters concerning domain name infringement on Nominate and UDRP. Welcome, both of you. So starting with Humna, like we see in today's global marketplace, cross-border trademark infringement is becoming increasingly prevalent. So what are some of the most significant trademark issues and infringement that businesses encounter when engaging in international commerce?
Thank you, Avani. So from the work that we do, and I think that the infringement landscape at the moment, when we're talking about international commerce, more often than not, it will now feed into e-commerce because businesses are moving online. Because as you said at the beginning, the world is getting smaller and trade is occurring between countries at much lower levels than at the higher distribution networks that it used to be. Because of that, what we're seeing is that the patterns of infringement and the importance for clients for these cross-border infringements tends to lie in things like domain names. So just to give you some background, when we have registration trademarks here in the UK, you're looking at, and I'm sure this is something Sanjay will cover in further detail, you're looking at protecting either a word or an aspect of something which can be identified particularly and put down in one categoric place. So clients will have trademarks that are registered for words, or they'll have logos or something like that. So we are able to use those registrations from the UK IPO to protect things like their domains, even though they may not have sought protection for, electronic or IT services. So what we see is that when you're having issues for selling these things online, you will see domains pop up where third parties have sought to register the client's trademark within the domain. So, for example, if you had yellowwellingtons.com and you had the trademark for Yellow Wellingtons, you might see someone who registers yellowwellingtonsuk.com or yellowwellingtonsforsale.com, just slight variations on your domain. What we're able to do is use that registration to recover those domains back for the client, because as you can appreciate, it's very damaging to the client's reputation, and possibly there'll be a loss of sales if customers believe that those domains are owned by clients. So one of the things that we suggest to clients is that when you're looking to protect your brand and you're looking to protect your e-commerce kind of net globally, you should maybe look at looking to register your domains and the various kind of suffixes for the domains that you have. So, for example, I mentioned .com there. The other ones that you could do is .co.uk or .co or .international. So the various GTLDs, which we call them, so generic domain name protections. So that's one thing that clients can look to do to seek protection. The other thing that you can do is there are actually domain name registration watching services. So there are third parties that if you give them the actual thing that you've got registration for, they will make sure that they look at registrations every month for clients and notify you if they think there is anything within those domains that might be a potential problem for you. A lot of the clients that we work with tend to do that in-house because all it involves you doing is doing a Google search and seeing what comes up. So if clients are looking to save money, that's something that they could maybe calendar something to do every month just to see whether or not their market is being protected the way they want. In the event that those things happen and somebody takes their domain, one of the things that you can look to do is enforce your trademark by seeking recovery of that domain. First, informally by contacting the domain name holders. And then if that doesn't get you the solution you want, the alternative is that subject to what the type of domain is, you can either start nominate proceedings or UDLP proceedings, which are a more formal form of action where you can invoke certain rights and ask what is essentially an independent regulator to give those domains back to you and have the content taken down. The other thing, which probably comes hand in hand with domains, are social media pages and social media handles. Because when we're talking about e-commerce, you're looking at building that brand, building that reputation by registering certain handles on Instagram, TikTok, whatever the format may be. So what we're seeing is that clients tend to encounter people who are impersonating their social media handles, again, to benefit from the reputation behind the trademark. So again, there are informal ways that you can have those handles removed by simply contacting the likes of Instagram or TikTok, but it's something that you need to be aware of. Then finally, this is a broader subject within itself. There is the issue of grey market goods and infringing items which may have trademarks on them. Now, the process was a lot more straightforward when we were part of the EU, where I could give you some guidance on how a big group of countries would deal with this. The problem I have at the moment is there are very few test cases, and our legislation is very much in the air in respect of how we deal with those kind of goods. But generally speaking, when you're looking at preventing goods entering UK borders because of the fact there are infringing items, what clients would need to do is firstly show that they have some degree of protection here in the UK, and then we would need to contact the various kind of governmental organisations which would be able to protect the offboarding of these infringing items. So it in itself is a very long process, and I think maybe that's for another session in itself.
Actually, thank you so much for sharing this. It gives a better insights into different kinds of issues and infringement that businesses encounter and what they should keep in mind. We often see that misconceptions can often hinder effective cross-border commerce. So, Sanjay, I wanted to ask you, what are some common myths or misunderstandings related to trademark protection in global markets that you would like to share with our audience?
Sure. Thanks, Avani. So I think the first point I want to make is businesses, and I get this often, is businesses don't tend to understand what aspect of their business they want to protect. So we talk about intellectual property as an umbrella term, but what does that mean? And there are various aspects within intellectual property that provide some type of protection for a business, but not all of those intellectual property is appropriate for the business needs. So in some cases, the business will need to go away and understand what aspects of the business, what intellectual property rights they hold within that business. So one of the misconceptions that we tend to see is misunderstanding what a trademark is, which essentially answers the question, who makes this product or who provides this service? And it's an important question to answer because in a crowded market space, you want your consumers to be able to instantly and immediately, without confusion, be able to pick up your product or service and identify your business within that space. So identifying what brands, what trademarks you hold is a very key aspect of the business. Humna, mentioned it in a talk just a minute ago that it's important to there are various types of trademarks available. So you can have the word mark, you can have the logo. Under certain regulation in the UK, you can even have things like sound marks or holograms. So there's a myriad of possible protections available to a business. But the downside to a trademark is essentially from an international perspective, trademarks tend to be what we call territorial, which means that you only get, if you go to seek protection for it, it's only protectable in the territory that you go to get trademark for. So, for instance, if I was to register a trademark in the UK, it would only give me rights in the UK. I wouldn't be able to extend that right. It wouldn't automatically extend my rights in, for example, India or even Europe. I would need to seek trademark protection specifically in those territories if I want to rely on those rights in terms of preventing or taking action in respect of any infringements or global issues. So the important thing one of the myths is that having a trademark in one territory automatically gives you rights across a broad range of countries, or even registering your brand in multiple countries or multiple main countries gives you substantial rights in the rest of the world. That is simply not the case. You need to be observant of the markets in which you trade in and determine which territories are important to you to get trademark protection in order to support you in preventing infringement or taking action against infringement. So on the point of trying to protect your brand internationally, what can you do? Well, there are a number of ways you can do this. The key thing is to understand the market space you're in, which countries you're trading in, and this becomes increasingly difficult, as Humna rightly points out, in a world where it's so much closer because we have social media in space. So sometimes things become viral in one country, and we get to see it in another country. How do you protect that knowledge, that brand? So you can either seek trademark protection by going directly through to that country and asking for a trademark protection via their trademark registries, or there is an alternative method which is monitored by and is dealt with by the World Intellectual Property Office, which allows you to file one trademark application covering multiple jurisdictions. Now, that might seem to people as an opportunity to file worldwide. It doesn't. There are some nuances and some issues, and that, I believe, is a separate conversation to be had about the nuances of filing in WIPO. But there are these are the two main methods of trying to get protection in those territories outside of your home country. The other thing to think about is also, if you are registering or if you are trading in a foreign country, what is their relationship with the neighboring countries? So sometimes you might be trading in the US, and you might think, well, what is their relationship with Canada or New Zealand and Australia, for instance, where they have very close relationships with one another? It's important to understand that and how that might affect your business from an international perspective, and whether there's infringement happening in one or the other countries. So having that in mind. The other myths and misunderstandings that tend to happen here in the UK particularly, the fact that owning a domain name in of itself, or registering a company name in the UK automatically gives you rights to those brands, to that brand name or that trademark, but actually it doesn't. It gives you it allows people to see that you're using it, but only a trademark will give you a monopoly in that specific brand name. So, which is why it's crucial to ensure that you identify what brands you have, and go get them registered sooner rather than later. The other point to make is where you have commissioned work for things like the logo or even aspects of your website. Again, specifically in the UK, what you might need to do is ensure that you as a business own the rights to that, either that logo, that design, or the website content, because generally under copyright law, what tends to happen is the person who's created that is the owner and can do whatever they want to do with it moving forward. So it's important that right is assigned over to the business so they have full control of whatever else it is. Yeah, and then the only other point I wanted to make, really sort of to finalize, it's a point to think about more than anything else, is if you're looking to register your brands in other territories, bear in mind the language and the the culture within those countries that you're registering in. So there was an old sort of a comical statement where the word Nova in UK didn't mean anything to the English-speaking consumers, but in Spain, Nova means doesn't work. So if you apply that to, for example, a vehicle in Spain, that implication means that car does not work, does not function. So that trademark has a different meaning. So understanding the cultural meanings of the words and that sort of thing is important in building a better strategy for cross-border protection. And also then being able to control how that is used.
Are there specific laws that govern these cross-border trademark infringement, and how does the legal landscape differ from country to country? Additionally, also, what kind of relief one can expect?
So that's a lot of questions in one sentence. So what I'll do is break it down. So firstly, are there any specific laws, I think you said, that govern cross-border trademark infringement? So in respect of that, in short, the answer is no. And the reason why it's no is because in the UK, what we have is one act which determines trademark infringement. And in order to benefit from that act, you need to, as Sanjay said, you need to have rights within this territory to be able to invoke those rights. That being said, there's a difference between trademark infringement and if you, say, obtain a judgment from another country and you're trying to have that judgment, so a successful action enforced here in the UK, that is a very different route and you're asking me a different question. But if that were the case, there are different means by which you can have that judgment enforced. We'd have to look into A, when the judgment was given, B, the territory in which that judgment was given in, and then there are various different statutory rights within the UK which may permit that right holder to invoke those rights here in the UK. So there's a bit of a nuance between what you've asked and what the possibilities are. The second part of it, so how does the legal landscape differ from country to country? Now, obviously, Sanjay and I have experience in the English jurisdiction, and then a lot of the perceptions and the advice we give is limited to that area. And that being said, we're only, I think, 2 years post-Brexit now, so we do have quite significant European knowledge, and Sanjay still gives a lot of advice in respect of EU protectability and the remits of people's marks and how you can interplay UK registration with EU registration. What we can say is, with the experience that we have, we know, for example, enforcing a mark or litigation in the US tends to be significantly more expensive than it is elsewhere. When you have EU registrations and EU protectability, a number of the thresholds are still very similar to what we have here, so the process is still quite similar. But I would say to clients who are considering I suppose, what kind of jurisdiction they want to enforce their rights in. There are certain countries, for example, Italy is known as being the Italian torpedo, which means that if you want litigation to become a menace to somebody and you just want it to be part of the system, it's known for proceeding for years and years through the Italian litigation system. So that's something that if your clients are considering or your viewers are considering, it's something that you should take into consideration. But my suggestion would be, if you're looking at protection in various countries, you should go and speak to people who have experience within that specific jurisdiction to give you the advice, because there will be local knowledge and practical knowledge that they will benefit from. So I suppose the third part of the question is what the legal recourses are available to businesses who have trademarks infringed in other jurisdictions. So if you're asking, so for example, here in the UK, if you're saying how far can your trademark protection go to, if you have a UK mark, one of the benefits is that you have monopoly rights. Sanjay kind of outlined in detail in the previous question, where you are the only person who has the rights to use that mark for various goods and services. But the problem, and I suppose the negative to that, is that it does not give you the complete right to go around the world slapping that right on every single person. You are limited to this jurisdiction. But what you could consider is possible worldwide protection via the Madrid Protocol, depending on what type of mark you have. And you may want to consider whether or not the UK, England is still the correct jurisdiction, because albeit you may not have the infringement happening in this country per se, in that the goods may not be being delivered into this country, but if you have a UK mark, because of the fact that infringement is so broad in its description, so it can mean use of the mark without permission, it can mean applying that mark to goods and services. If you can show that that's happening, technically you could bring an action in this jurisdiction. You wouldn't need to consider forum shopping. The final part of the question is, what could a client expect in terms of relief? So again, I can only give you an idea of in England what those relief options would be, but the most important thing for clients outside of money tends to be a injunction, which would prevent anybody else from using that mark, because that's why you've started the action. You don't want anybody else to use that mark. The other thing that, if you're successful, and I kind of emphasize and stress that if you're successful, one thing that you will get is your costs to an action. So subject to what kind of route of litigation or route of enforcement you pick, you may be able to recover a part of your costs. Now, when we were talking about myths earlier on, one of the things that a lot of clients have trouble appreciating is that even if you're a successful party in a UK action, you will not be able to recover the entirety of your legal costs. So it's very, very unlikely that you'll ever recover 100%. You will recover a percentage as a contribution, but you will never recover a full amount. So when we're having these discussions with clients, it's important that they appreciate that, because legal bills can be high, but that's why I say that an injunction is probably the most important thing for a client, because there is no value that can be attributed to that. And then obviously you've got the things like damages, you've got the account of profits, which could be a thing for clients to recover. And then one of the more kind of, if the client is making a point by embarking on this litigation, one of the things that is provided by the UK courts is that you can actually have that order or a judgment published on the defendant's website. So if they're trying to make a point and they're trying to get, one over on the person who's infringing their rights, that can be a really good thing. So I think I've covered questions that you've asked. Is there anything else you want to follow up on?
No, thank you so much for covering all of that. I think it provides a lot of information to the audience. Trademark protection is crucial for businesses operating across borders. So, can you give some strategies or measures that companies can implement to safeguard their trademarks from infringement, considering the complexities of international trade and differing legal systems from nation to nation?
Yeah, it's a very interesting question, in particular because of the fact that there are differing laws, interpretations, processes even of dealing with infringements, assessment of confusion in the marketplace between marks and so on. So I suppose one of the key strategies, and I think it's often overlooked, if I'm completely honest, is the business spends time protecting their assets, namely, one of the things might be the trademarks or the intellectual property generally. But what people or businesses tend not to then do is monitor what is happening in the market spaces that they're in. So one of the key recommendations that we would make is, if you have a trademark registered in the territories that you are trading in, it would be sensible and prudent to make sure that you are monitoring the market space that you're in. The trademark register is probably the easiest way to monitor if anyone is trying to file identical or similar trademarks that could be problematic in the space that you're in. Additionally, there are some, I think Humna mentioned also, domain name watching services, which is a crucial point as well, because what you then don't want to do is someone using a different GTLD to yours, but using a similar brand to your similar brand name to yours. You want to be shutting that down. The point with all of these monitoring services or engaging in monitoring services is that if you don't monitor it and you don't take relevant action, and you might not take relevant action in respect of all issues, but what you then do is potentially leave the door open for people to get confused, or that the question that I posed before, what is a trademark, for instance, and it answers who makes this product or who provides this service, that answer becomes very muddied because you're not able to clearly set out your stall in that space and say, this is who we are, this is what we do. So monitoring services are crucial. Understanding your market, understanding where you trade, understanding actually how far does your brand reach, so in instances, if you're selling on marketplaces, where do you sell to, who has access to those brands, do you need protection to protect that element of it? So that's consideration that needs to be taking place internally, and take a look at what's happening with your consumers. Who are they? Where are they based? So yeah, and the reasons for setting these up and looking at these points is because once you identify that space, you can then put in strategies to say, well, actually, here's how we can mitigate the risk or add in some kind of protection that will help with that. So the other point with that, I suppose, is to make sure that you are ahead of the curve in that respect, that you are not trading in territories without having obtained relevant trademark protection in place, because more often than not, you might end up in a space that you may not be able to use your trademark in that space, and then there are issues with that, or you're not able to enforce your rights because someone has got into that space before you have, and because you've not taken the relevant due diligence in terms of that. The other strategies you could employ, I suppose, are using, for example, if you trade on things like marketplaces, is using their protection systems that are in place. So sometimes you can register your trademarks with certain marketplaces, which then allow other identical similar marks to be shut down relatively quickly, and it makes for preventing others trying to trade on your brand name much easier. So I would say the bottom line is, if there are issues in relevant territories that you trade in, it's always worth going to a local attorney there and getting some expert advice in respect of those laws specifically for that particular matter, but having a broad understanding that actually ultimately, if you don't have protection in one territory where you are having these issues, you need to address that. So the easiest way to do that is to make sure beforehand you've taken the relevant steps to protect your assets, your business.
Yeah, I think this gives a broad understanding of different strategies one can take care of or implement. Humna, do you want to add something to it?
No, I think Sanjay's provided a very detailed overview of what the different strategies should be. And I think all I would do is echo the point on seeking local advice, because I know we've kind of gone on about how UK law and UK jurisdiction is specific, but because of the fact there are so many various options by which you can protect yourself with your trademark and enforce your trademark, there are different options and there are different market reasons why you may prefer one over the other. We, in a specific jurisdiction, give you an idea of what trends are. Firstly, what where we're seeing things for clients as being the most successful routes. The other thing we can give you some guidance in respect of is, commercially speaking, which is more likely going to lead to you or people achieving the objectives that they want to. So there are strategies that we can generally give, like Sanjay said, in each one of those options. There are different benefits, different drawbacks. But when it comes to a specific instance, I would say make sure that you do go and speak to a legal specialist within that specific jurisdiction.
Thank you so much for sharing that. And thank you so much, Sanjay and Humna, for being part of this discussion. I hope this panel helps everyone understand a lot about cross-border trademark infringement and protection from issues related to it, myths associated with it, and also some reliefs and laws associated with it, and what are strategies or measures that companies can implement to safeguard their trademarks from infringement. So thank you so much for being part of this panel discussion.
No problem. Thank you.
Thanks for inviting us.